time for one question before we wrap up. And again, I'm going to sort of put this to all of you if we can. I know we've covered a lot of information, so if we can just briefly, help our attendees with just a little nugget in answering this question here. So, do insurers have the same right in bad faith litigation to discover privileged communications between the policyholder and plaintiff counsel? Ned, you want to start with that, and then we'll move on?
Two answers. There are no reported decisions, at least as of the last time I looked, which was a couple of months ago. The second answer is maybe. And it's beyond the scope. We don't have enough time to go into it. However, in states that recognize that the insured has the implied covenant of good faith and fair dealing with the insurer, just as the insured does with the insured, then it is possible to create an argument. And I've actually done it in a bad faith case, and countered with bad faith of the insured and or the insured's attorney, and the attorney backed off of the request for privileged communications between my client and its coverage counsel. But if anybody wants to go into it in further detail, anybody in the audience can certainly contact me. I'll be glad to discuss it.
Thank you so much, Ned. Michelle, any thoughts on that?
Well, I think it depends. If, for instance, plaintiff's counsel is involved pre-litigation in negotiating the claim and has communications with the insurance company, and there's nothing in place as the equivalent of what we call in California white labor, then I think that the communications between plaintiff's counsel and maybe what was going on with the policyholder, you may have a better argument. But overall, they're going to argue that it's protected by the attorney-client privilege. But certainly, the counsel's communications with the insurance company pre-litigation would not be privileged.